CRPA versus LA Sheriff's Department lawsuit is back in the news. This was our challenge to the CCW permitting regime and how it was being applied by LA County. We got another order yesterday, and there are some things that the government is slapping California with. Let's talk about it. Hey everybody, welcome back to the channel today. We continue to see progress with Second Amendment litigation here in the state of California. This one coming to us yesterday from the district court. We are seeing progress in the CRPA versus LASD lawsuit. And to walk us through that today, we have brought back on CRPA President Chuck Michel. Chuck, thank you for being on with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. And guys, once again, before we get into this today, please be sure to like, share, and subscribe to these videos. It really helps get the info as far and wide out there as it can, and it's a great way for you to directly contribute to things just like this, which is the progression of Second Amendment advocacy with legislation and litigation here in the state. So, guys, there's going to be a little bit of reading today. Can't really get around that, but wanted to catch up. Those of you who have not been following along, of course, last year we had this lawsuit going through the federal district court. This was our challenge to the archaic regime of CCW permitting LA County and really a couple of others, but the lawsuit ended up being in LA County just because they are not applying the Bruen standard here in the state when continuing to process CCWs. Let's provide a little bit of background. Jacob, can you pull this up really quick? I wanted to read it from the order itself. It reads like this. On January 26th, 2024, the plaintiffs moved for a preliminary injunction requesting that the court enjoined what they characterized as certain unconstitutional practices under California's CCW licensing regime that delay or deny plaintiffs constitutional rights to carry. These practices include 1, alleged delays in processing CCW applications by the LA Sheriff's Department, 2, alleged denials of CCW applications based on forbidden suitability determinations allegedly used by the LA Sheriff's Department, 3, psychological testing requirements implemented by the Verne Police Department, 4, the alleged excessive application fees instituted by Verne Police Department for CCW licensing applications, and finally 5, an in-state residency requirement for CCW licenses. And perhaps that's the one that ends up being the most notable from this case so far in the product that we've seen. But Chuck, just so that everybody can catch up with us here, these were the initial complaints that we had in the lawsuit over a year ago. Can you go ahead and just rehash the original opinion by the federal district court judge and what brought us to the order today?
Well, yes. Remember, CRPA has been running the CCW Reckoning Project ever since Bruen came down. We've been sending educational letters to some jurisdictions that weren't overtly hostile to issuing CCWs, and then pre-litigation demands to the ones that were dragging their feet. Many of the jurisdictions came in line and started issuing permits without trying to throw up roadblocks. But some jurisdictions, which have historically always been anti-gun owner and anti-CCW, like LA County Sheriff, have taken too long to issue CCWs. For example, it can be 18 months to 2 years to get your application through a process for a 2-year license. So it's ridiculous. But other jurisdictions were charging too much, like Verne. And then the DOJ was not accepting would not produce an application form for out-of-state residents to apply for a CCW in California. So we sued the DOJ, the LA County Sheriff, and the city of Verne in this lawsuit. Verne came to its senses, lowered its fees, and settled the case and got out of the case. The DOJ is in the process of settling the case because, as a result of our first request for a preliminary injunction, the court said you have to accept applications from out-of-state residents. So DOJ is now setting up a process to statutorily recognize what the court has already ordered, which is that if you're a CRPA, SAF, or GOA or GOC member, you have standing, you can apply for an out-of-state license. That gets into associational standing, which I'll cover in a bit more later, which is why you have to be a member to apply from out of state. But that left the LA County sheriff and their whole process. And they did not want to give an inch in issuing this, which is a bit, to tell you the truth, insulting, to say the least, that they tried to say that we have CRPA and the other partners had no standing to challenge the law, that the 120-day statutory limit on how long it can take to issue a permit was basically a right without a remedy, that no one could enforce that law, especially not CRPA. And and then they also argued that all they got to do to moot the case is issue a CCW to the individual plaintiffs, and that CRPA has no associational standing. And this is a big battle that's going on in lots of cases right now, where they try and say that the groups like the CRPA, Second Amendment advocacy groups, don't have associational standing to challenge an unconstitutional practice on behalf of their members. So we went to mediation to try and get the county to put more resources into this so that they can process the applications faster and to get some of these roadblocks out of the way. But to be honest with you, they were rather smug at that hearing, and they wanted to get this ruling from the court before they agreed to any kind of acceleration of the CCW process. Well, now they just had their butt handed to them by this judge in this ruling, because the judge has said that CRPA does have associational standing to sue on behalf of its members. That just because you give an individual a CCW doesn't mean his claims or her claims are moot, and they can still stay in the case and advocate for the rest of the folks who are being delayed. And that there's no immunity for the sheriff because he's not acting as a state actor in this case. He's implementing a county policy. They tried to get out of that by claiming that they were immune from prosecution. There's a 1983 civil rights action here for at least for attorney's fees, if not for some damages for these people who have been deprived of their constitutional rights. So this was a big smackdown of the LA County and all its arguments that it was trying to make to get out of this lawsuit. And now they're going to have to face the music, because CRPA is not going to, now that we've won this, we're not going to be inclined to show a hell of a lot of mercy to the extent we ever were, because the LA County Sheriff, like the LAPD, has been notoriously anti-Second Amendment, anti-gun owner, anti-CCW for decades. So this is the beginning of of change at the LA County Sheriff. And because of this lawsuit, the United States Department of Justice is looking at the LA County Sheriff and has a pattern and practice investigation ongoing. And we will be sending this right to the folks that we are communicating with at the US DOJ, sending this ruling, letting them know what the judge just held, so they've got more reason to get involved and put a stop to the LA County Sheriff's shenanigans.
Well, I guess the intuition is working. You kind of just answered all the questions before I could ask them. I still think they're worth going through, though, here. So I guess just to kind of restate where we were at before this order came out, you kind of had three separate issues here. You had some high fees in Verne. You said that they got out and recognized the error of their ways by lowering their prices. You said that Cal DOJ is in the process of doing the same thing, which was really the big thing that came out of this lawsuit at first, which is to recognize that out-of-state citizens should be able to get a CCW in the state of California. But then you had LASD kind of being stubborn. So they came back, and Jacob, if you could actually pull this up, I wanted to go through each one of these points because, and Chuck, I know that you already kind of summarized it here, but I wanted to go into these individuals just so that we could understand what they are arguing point by point. So it reads like this: the Los Angeles defendants challenge the standing of CRPA, SAF, and GOA to secure relief for any of their members who are not parties to the litigation. In other words, anyone other than individuals. The Los Angeles defendants also also argue GOC and GOF should be dismissed from the lawsuit altogether because they have not alleged they have any individual member who is party to this lawsuit. Second, they argued on plaintiffs asserting facial challenges. The Los Angeles defendants assert that FASC should be dismissed to the extent it lodges a facial challenge against the statutorily permitted response periods in California's licensing regime because they argue plaintiffs' FASC challenges only the application of the license regime to the individual plaintiff's permit request. Plaintiffs respond that FASC does in fact sufficiently mount a facial challenge to the LASD's practice of exceeding statutory limit. Here, plaintiffs challenge the policy or practice of the Los Angeles defendants, whether official or unwritten, to take 2 years or more to process CCW permit applications. Third, the Los Angeles defendants argue that the LASD is entitled to immunity under the 11th Amendment and that Sheriff Luna is immune from plaintiffs' claims for nominal damages as a state actor in his official capacity when administering the CCW licensing program. Plaintiffs disagree, arguing that because the FASC alleges the Los Angeles defendants are not following the state law, the LASD is not immune, and Sheriff Luna is liable for nominal damages. The court first addresses the immunity of the LASD as an arm of the state and next turns to whether Sheriff Luna is a person subject to monel liability under 42 U.S.C. 1983. Next, and the last one was on mootness of two plaintiffs' claims. The Los Angeles defendants argue that plaintiffs Messel and plaintiff Weimer's claims for injunctive and declaratory relief are moot. The Los Angeles defendants argue plaintiffs Messel already obtained full relief when he receives his CCW license on May 2024, and plaintiff Weimer, who already obtained full relief because the PI order issued by the court required plaintiff Weimer to receive a decision on his application on a specific timeline. Plaintiffs argue that plaintiff Weimer and plaintiff Messel's claims are not moot because, among other reasons, plaintiff Weimer and plaintiff Messel have requested nominal damages. The court agrees with the plaintiffs. So, Chuck, you kind of already went through it here, but we got we got an order that was partially granting and partially denying this. Can you just go over these four things again? And perhaps the mootness is kind of a question for another video. I know that the Trump v. Casa decision from the Supreme Court talking about universal injunctions and how the court applies relief to individual plaintiffs is kind of a talking point, especially in the Second Amendment community. How does this translate? But going through these things here, are we getting wins on all of these things or just a couple of them?
We basically won on all of them. The reason she granted some of the state's requests, but she said, here's why I'm granting it. Here's what you have to do to fix that. And you have leave to 21 days to amend your complaint to fix these things. And then the state will lose on the county will lose on the rest of its arguments. So this was pretty much a win all the way around. We've got a few little tweaks to do on the complaint. She basically showed us how to do it, told us what we need to do. It's easy enough to do. So we will go in and make those slight corrections. And then this case is going to go on, and LA County is responsible. The sheriff is responsible for issuing permits on time. And we're going to force them to do that. There will be our next request will be for judgment against the county and a permanent injunction forcing them to issue permits within 120 days or to whatever they're claiming that they don't have the resources, they don't have the money, they don't have the manpower. Well, you know what? We didn't write up the system. The state created a system that they've always tried to use to discourage people from getting a concealed carry permit. And it's not our problem if it costs a lot of money to actually administer the system. Take the money away from illegal immigrants that don't have a constitutional right to something, or to other pet causes that LA County finances that it shouldn't be spending money on when it's not spending money on protecting the Second Amendment constitutional rights of gun owners, which they've never really liked. But now it's being forced down their throat by the Supreme Court and by this judge's ruling and by the CRPA and our partners.
Is this sort of I'm thinking about the process now. We had the original order talking about the out-of-state licensing process for out-of-state CCW licenses. Here, this is on a completely different thing. I know that LA came back, which this is addressing. Does this back and forth continue, or is this kind of one of the final steps towards the conclusion and a judgment in this case?
Well, remember there was three defendants. Laverne is out. The DOJ is about to get out because they're capitulating and setting up a process for out-of-state residents to apply. And the LA County Sheriff was playing hardball, but they just got slapped down. So we'll see. We've made some proposals for them to streamline their system and get some competent consultants in there who can tell them how to do it more efficiently. I mean, Riverside, San Bernardino, Orange County, they don't have these kinds of problems. I mean, there's more people applying in LA County. Apparently, there's about 8,000 applicants that are backed up. But if you do it right, if you do it smart, like the other counties do, and drop some of these things that get in the way, some of the procedures that get in the way of processing the applications more quickly, they can get through that backlog fairly quickly and then keep up with it as people continue to apply. And we want to encourage people all over the state to apply for a CCW in whatever jurisdiction they live in and get one, because this is what will normalize firearm ownership in the state of California. In other jurisdictions, 40 other states that have liberal, it's easy to get a CCW as long as you're not a prohibited person. People who get used to firearms and they're not afraid of them anymore. And that's what scares the gun ban lobby and the politicians and law enforcement officers that are supported by or supporting the gun ban lobby. They don't want people to understand that guns have social utility, that guns are fun to shoot at the range, that guns develop self-discipline and sportsmanship and responsibility, and not to mention they're a huge deterrent against criminals who think that they can go into a gun-free zone where nobody can have a firearm and kill people without consequence. That it's a huge deterrent when criminals don't know who's armed, who might have a CCW. They don't go in and try and commit the crimes that they otherwise would.
Yeah, the intent kind of becomes abundantly clear when you just have access to so many different things and you decide to take specific routes. If resources is an argument that's being used here, I didn't exactly see an endorsement from legislation this year in California that was proposed to extend the period of a CCW from 2 years to 4 years. I mean, it's pretty well assumed that would really help on the resources end, get people through the CCW application program. Didn't exactly see an endorsement from Sheriff Luna on that. So is it really about resources, or is that just what you're saying to enforce the actual kind of programs that you want to enforce, keep CCWs out of LA County? So good on you, good on us, and good for the community to get these wins here. I guess on final thoughts here, Chuck, I'm sort of curious, do you see this potentially being appealed to a higher court like the Ninth Circuit, or does it live here?
This was on a motion to dismiss the complaint. That's not something that they're going to appeal. They may try and preserve these issues for appeal, but I don't think they stand a chance. This is not like the Bruen application. These are, the doctrine of associational standing, the doctrine of mootness, the doctrine of civil liability. Those are not things that deal with the Second Amendment per se. These are things that are bodies of law that have been developed over time through various constitutional issues, not just the Second Amendment. And so I don't see them wanting to go that far. They're going to now have to come to the table, and they're going to have to make it a priority to process these applications quickly and not set up unnecessary roadblocks that'll slow the process down.
Well, certainly good news. We got a lot more to look forward to. I know that we've got the application to SCOTUS to look forward to as far as Second Amendment litigation is concerned in the Duncan case. We've got a lot of other strong arguments in the Ninth Circuit, but this one is definitely adding to the pile that is making progress. So that's great. Chuck, did you have one more thing?
Yeah, don't forget, this is part, remember, I opened with this is part of the CRPA CCW Reckoning Project. We are not stopping with LA County Sheriff. LAPD is next for their delays, and Santa Clara County is next for their excessive costs. They're charging upwards of over $1,000 to apply for to put your application through the process there. They're getting sued probably this week. We got a little sidetracked with some of this stuff with the sheriff's case, the LA County Sheriff's case, and LAPD is on our list in a week or so. So support our efforts. We will keep. And by the way, when you win in LA County, it helps all over the state. This becomes precedent for our next lawsuit. So it's kind of like whack-a-mole with some of these jurisdictions where they try and jack up their fees or take too long. We're going to keep whacking them down as long as we get support from our members and donors and supporters to keep the ball rolling. We keep our fees as low as we possibly can. We're very efficient, and our finance committee and our accountants keep an eye on all those bills. Nobody's getting driving a fancy car out of these lawsuits, but we are. It does take time, and so we do need the support to keep the ball rolling. But help us out, and we will.
Well, with that list growing there, I guess you've just made your way on my list for future videos here in the next couple weeks. Look forward to going through those individually with you. Thanks for coming on, Chuck. I appreciate it.
My pleasure, guys.
Absolutely. And guys, one more time, if you like this kind of content, you want to continue to see it, you want to continue to be updated by the people who are working up in Sacramento on this legislation and by the people who are working in the courtrooms on this litigation, please be sure to like, share, and subscribe to these videos. It really helps get the information out there. Thanks again, guys. We'll see you on the next one.